Okay, so concerning product indication, I would also before that like to talk a little bit on how we do the examination in our office. Okay. Okay, so just to be brief, is we get a design application and we have a collaborative team which is called DICE. These are the colleagues who do first examination of trademarks. As my colleague Christina was saying, we do very basic examination. So basically, we check the formal requirements. So if the data of the applicant is inserted correctly, if there is quality of the design, if the design complies with our standards, our requirements. We also check if fees have been paid. And for the substantial examination, we check if the design complies with the definition of the design and well, the definition was which Christina showed you, and we also check if it's not contrary to public policy and morality. So if I'm not mistaken, I was having a look on your website. I think you also check against health. So it's like public policy, health, and morality, if I'm not mistaken. So we have it similar but slightly different. So normally what we do is that the group of experts, they gather every day, normally in person now, but before with the pandemic, they were gathering virtually. They are put in pairs. So, well, everyone examines they pull designs applications, they examine in case they have a question, they have colleagues to ask, and if there is really a doubt about the design, then they discuss it within the forum of that day, or it even goes further. We have a group of experts, the reference persons, and they can also discuss the most difficult cases and decide on the acceptance or on maybe objection of the design. But I can tell you that uh, 85% of the applications go through, so there is no deficiency. In case there is a deficiency detected, we have a new system. Well, it's not so new, but relatively has like 2 or 3 years. And the examiner from DICE, he or she marks what they spotted. They leave an annotation, and it's a kind of, let's say, quality check what happens, because this same examiner normally does not draft the objection letter. There is another examiner who pulls the case, reads the annotation, and drafts the letter. So this is like a nice peer quality check, because the examiners can discuss no further if what's going on, how to approach the case, and so on. So apart from that, of course, we also have standard quality checks. And we also have the policy of zero inbox. So what we do is that normally the applicants, when they apply for the design, they can choose the fast track option. So the conditions for fast tracks are basically that they have to use the design class, which I imagine you are familiar with, because if you were saying that you know design view, then I imagine design class is also familiar for you, which is the tool that we offer and is based on the Locarno classification. So they have to use this, they have to pay upfront, and there have to be no objection raised. So if the design application complies with this, then it can be registered within 2 working days. So what we do normally is that when the application comes, what counts is the date, not the time. So we can have a fast track application which enters at 11:55 at night, 23:55. It counts as the first day still. So what the examiners do, they pull the cases from the day before, they check them, and if everything is fine, they go for registration. So this way, we never have cases of the day before at the end of the day, let's say. And also, we also for regular track, our commitment is that we register within 10 working days. So we also try to have our inboxes clean on day at least on days 4 and 6. So if the design is older than 4 days, the examiners extract it quicker than a design which was maybe filed two working days before. Okay, so apart from that, this is our system, the EUIPO system. I believe I don't have to introduce it. It's the European Union, 27 countries. The applicants get protection for the whole territory if everything is fine. And there is also the national system, so the applicants can go for to different countries. Like I'm from Poland, they can go to Poland, to Germany to register their design, but still we consider it's easier for them to just go to the UIPO, have one representative if needed, and to file with us. It's one set of procedure, one fee, one representative if needed. Um, but also, well, what they can do is they can file in a country and then claim priority. We have this possibility of claiming priority. And there is also another layer, more international, which is the WIPO registration. I will talk a little bit later about WIPO and how we at the UIPO deal with that. So basically, this is that. And also, we have in Europe two systems, which actually yesterday we were discussing a little bit with Linda from Indonesia about the systems that we have the registered European Union designs, but also we have unregistered option for the applicants. And I was discussing that in the first day. I don't know, any of you were here on the 30th of September? No? Okay. So maybe I will just briefly introduce it. The unregistered EU designs is a right, which is obviously, as the name says, it's not registered right. It's very basic. It's from the moment of a disclosure of the design can become unregistered one. There is not really a database so far, so it's the burden of the owner to prove that they really have an unregistered design, which from experience we've seen it can be a little bit difficult, but it has to be disclosed for the public. Like Christina before was saying, it's for example disclosure only to your partner, well, to applicant's partner within a confidentiality agreement. It's not considered a public disclosure. It has to be a trade fair, an exhibition, any material which could serve. And unregistered designs only protect the applicants against exact copies. So then we have the registered European Union design, which is, well, they have to pay, but they get the certificate of registration. In our case, it's for 5 years, extendable by 5 years periods until up to 25 years. And then they have broader protection because it's not only against exact copies, it's also against the trading, import export of the designs, but also if someone else, let's say, came to the same design, but the design of our applicant, let's say it's registered, the one which is registered prevails. So that was quick. And then we have 30, then what I was talking before about the registration, 2 working days for fast track, 10 working days for regular track. But then there is also a possibility of deferring the publication up to 30 months. Okay, so let me now talk really about the product indication. I wanted a little bit to introduce how it is in our office, although I believe you are already familiar, but it was a wrap. So, okay, Um, Product indication, we do three things. Either it's an ex officio change, we do a suggestion, or an objection. So, what are the differences in these cases? So, well, in case the application is, for example, for sneakers, then we go to design class. We cannot really find this, so we ex officio change to sport shoes in this case because product indication and descriptions are not mandatory. They are, well, they are mandatory, but they are not legally binding. So why we change this? It shouldn't be so relevant, but it's for the search purposes in that case. So we always want product indication to be in our database. Then in the second example, you have here that the product indication inserted was graphical symbol, particularly for animation characters, dolls, and ornamentation of objects in general. Very long, not necessary so much information, so the examiner here changed it ex officio to graphic symbols. In such cases, when we do the change ex officio, the examiner just informs the applicant in the registration letter. Then what we also have here is that, for example, if someone put porcelain and we see that there are plates, cups, and so on, we just add these prefixes or sometimes suffixes. So in this case, set off, the same for this furniture, and also in this case, part of. And then also if the terms are too general, like in the first example, they put furnishing, but actually there is a clear class and subclass beds. So if the indication is too broad, we also try to narrow it. And the same for the second example. And also in case there is an obvious mismatch, but just it's an error, then we also change the indication of product. Then what we also have are suggestions. So for example, we can, we can also propose to shorten the indication of product or to change it. Sometimes, well, as in this case, we have very long indication of product. It's not really so necessary. So, but just to be on the safe side, the examiner suggested to the applicant printed matter, because maybe in this case it was not so clear if um, if that was exactly what the applicant was looking for. So these long lists of product indications are normally, we try to shorten them. Um, we also, when they put very detailed, as in the previous example, we try to make it more global, but also sometimes what happens to us is that the applicants put quite a broad category and there is something more specific. So we do we do these changes. Okay, so in this case, what happens is that the examiner sends a letter with the suggestion, or we also try to call the applicants, because in such cases, maybe just with a quick call, we can solve the issue. If not, if the applicant does not reply within the time limit or it's not reachable by phone, then the examiner will proceed on the basis of the product indication as proposed by said examiner. And then the final part, what we have here is when we actually send a real, let's say, objection. It's when we don't know what the product indication is. And the product indication does not match actually with the image. So it's not possible to classify it because the indication is not understandable, it's too general, and the product cannot be defined by the image, or there is really an obvious mismatch uh, between the two. So in such case, the examiner sends an objection, provides 2 months to reply, But if the applicant does not reply, we always, as said, we always try to call the applicant. So we really try to solve anything, any issue, because in such case, in this case, then the design will be rejected. Okay, and then what happens if they are multi-purpose? Then in such case, the applicant has to indicate all the purposes of the design. So here what I was saying, but I believe later on, Christina will also show, or you will show on the design view. Both. Okay, so I will not enter really here into details. Do you use normally design class also, or you use other tools? Ah, that must be an easy question. Yeah. You use design class, this one? Does it ring a bell? You use directly Locarno? Yes? Okay. Well, then maybe then your workshop after lunch could be also interesting because we have some explanations and so on. And by the way, thank you to the lady who was nodding. So at least I could see uh, uh, how how you deal with that. And in Indonesia, you are using the design class or also Locarno, basically. Locarno. Okay. Maybe that would be of interest to you. This is the database that the EUIPO developed with 24 participating back then EU offices, also with some non-EU offices, user associations, and WIPO. So this is quite a global database, and it gives some general remarks, some indications. So maybe it could be of use for you to have a look on it. We do use it a lot in our office. So basically, when there is something which we cannot find in design class, then maybe we go to Locarno. But this is this basic database which we use. But it's as said, I will not stop here too long because Christina then will show to you the details. Okay, so now I don't know, can you tell me where normally you find issues with product indication, in what sectors or in which classes? From your experience, anyone? You were not so shy with Christina. I'm a- I would like with more interaction. You've spotted some patterns. Maybe you talk sometimes with your colleagues where there are more problems, more issues. Okay, if not, then I will show you where we spot mainly problems. So indication of product by some sectors. So the sector which we found that we get more issues is with furniture, basically. So here I just prepare like a small image of also when it's not only when the applicants struggle, but we as examiners sometimes we struggle because in theory we have here one place, no, but we can have different classes of product indication. And actually, one example which sometimes we tend to forget, that's why our reference person have to remind us sometimes, is this one. This is the seat, which is very clear to us, but then you get this. Okay, forget about the plant. I know it's not neutral background. I imagine there is nothing there. So we have the seat. Well, fine, okay, but then we also have to add questions. So which is at least different subclass. So this is one thing which we spot that the applicants sometimes forget to add the second product indication, and even the examiners sometimes go straight to one thing. And then here another thing related to furniture. Well, we have obviously lights, mirrors, and cabinets, shower, different parts which can be in different classes and also in different subclasses of a class. So then another segment where we find some issues, it's cosmetics. So as you can see here, it's a quick overview of where the product indication should go. But basically, we also encounter a lot of issues. Well, this would be another probably example of non-neutral background if the applicant only wanted the cosmetic pack. To be reminded, it's not a cosmetic container, it's a cosmetic pack. But if they wanted everything, then they have to also put the cosmetic brushes, powder, the in this case, we decided it's probably the packaging container of a lipstick. So as we can see, one image and we can have uh, different uh, classes within one sector, let's say, no? So here we also um, remind the applicants and to ourselves that if there is no content where we should actually classify this, when there is content, or if we can't tell, normally we would go for this first indication because we cannot see. What we see actually, it's the packaging, it's the container. We don't know if there is a content. Here concerning the packaging, what how we normally classify. This is like an overview. And then concerning multiple applications, which was another topic. Well, before the legal reform, what we had, and I will jump this part from the legal reform because I'm telling it to you now. Before, the applicant had no limit. They could file, I don't know, I think we had filings with 200 designs, very long applications, but there was a requirement of unity of class. So what I was showing you before, it would be a no-go. They could not put cosmetic bag, brushes, a lipstick container. It wouldn't be possible. Everything had to be in one class only. But now with the legal reform, this was limited. So the multiple application can only contain up to 50 designs, but now the unity of class requirement has been abolished. So now all these things could go in one application up to 50 designs. And then concerning the Hague system, here it's what we do at the EUIPO, it's what I was telling you, what we examine, these things, and for substantive examination is the design definition, if the design complies with it, and the public policy and morality. And as Christina was saying, we leave for the applicants the applicants for invalidity for the parties to decide on the novelty and to show evidence and file for lack of novelty of lack of individual character, and then the first instance examines that. So what happens with the Hague system in our case is that, we are part of the Geneva Act since 1999, but the EUIPO can only be the designated office. The protection of the design, if it's granted for the EUIPO, then it will be the same as in our case. So for us, the design protection can be up to 25 years, and with the Hague system with EUIPO, it will also be 25 years. So we cannot function as the transmitting office. So the applications have to be submitted directly to WIPO and they check formalities. We only check these two issues. So again, the substantive examination. Uh, and we also, in this case, don't do the assessment of novelty and individual character. And the EUIPO does not republish the international design. But if the examination is successful, the design applied for in at WIPO will have the same effects as in our office. So that's the end of my first presentation. I don't know if you have any questions to that. Yes?
Thank you. Thank you, Catherine. Sorry, thank you, Monica. Okay, I would like to ask about your ex officio. Wait a second. Ex officio change of indication of product.
Mm-hmm.
So, you tell us about how the examiner sends the letter to the applicant or call the applicant, blah blah blah. But uh, if the applicant do not respond, so your office change the indication of the product. My question is that is there any possibility for the applicant to what is it, disagree about your decision in changing the application after you made it after you make it in information in your registration? So what is the process for the applicant to disagree about your decision in changing the
Well,
uh,
normally what we say is that the applicant is giving the 2 months, no? So because if we call, it's normally we try to get an agreement with the applicant. If we do not reach the applicant or they say they need some more time or whatever, then we do the issue the letter. So we give them this 2 months. So this is basically that. And afterwards, in case the office took the decision and the applicant did not reply within time, well, they should actually accept what has been done. But in any case, they can contact the office and give some explanation what happened. They can try to request changes in the register, but in principle, the time giving is the 2 months.
so it is possible for the applicant to have changes in the registration?
I will have to check that actually, if this is possible. But I don't think because it's not a minor issue. But in any case, as no, it's not. I'm sorry. I got blank at one point. It's no, because the indication of product is not a legal requirement. So at the end, this is not so relevant.
Thank you, Monica.
Thank you.
At first, I forgot my question. But okay, looking back, so as you may know, the EUIPO field is on the process of succeeding with The Hague. I just ask, what is your practice upon receiving the application from The Hague? So the examiner has to check, so it has to go to examination for the
Only.
two,
Only these two.
only the
Yeah.
two,
Formal requirements are checked by
only checked
WIPO,
by both.
and we only check these two things. It's very straightforward and quick examination.
So just for instance, an application offends public policy of EUIPO. So how do you reject the application? You send it to the applicant or to EU?
We send it to the applicant then. Yes, because as this is substantive issue, we can then contact the applicant, but we also inform WIPO in this case.
Ah, okay.
To be honest,
Thank you.
we almost don't have such cases. So very rare. Any other question? Okay. No, so if we can have the
We have one
second,
question.
sorry.
Sorry. Thank you for your presentation, Miss Monica. No? Uh, I have a couple of questions actually, but first, let me say that uh, we are very, we are only using the Locarno, no? So I think we will have a keen interest in your presentation of the design class this afternoon. So I will be waiting for that. Uh, First, I'm very impressed by your fast track, uh, fast fast track registration of industrial designs file trail. I wonder how you are able to do this in 2 days. Uh, how are how are the applications distributed to an examiner, and who is responsible for the distribution?
Mhm. Yes, well, it's super fast because it's, I was also saying we do not do this novelty search, for example. So obviously, if we only check the basic requirements, and normally also our application forms, they guide the applicants so that, for example, if they do not provide the name of the applicants, the form will get blocked, no? So maybe we have some issues with address because the address is incomplete and we cannot recognize exactly, or the legal form is not there, things like that, no? So it's like this, let's say the first filter, the forms which do not allow the applicants to get further if they did not, for example, sign the application, etc., etc. How we distribute, how we do it. From all the examiners who check designs, as said, we have this DICE group, and every day there are several examiners. There normally they are 8, 10 people. So we have our internal system where we can see like a kind of dashboard with all the designs which are unallocated to an examiner, so they are available to extract. And then in this dashboard, we clearly see the how old these examiners are, these applications are, if they are fast track, if they are regular track, and by language. Because also me as Polish, I prefer to work in Polish instead of a colleague who's Spanish, for example. No, so we then have like several filters, and we can decide what applications we take, and we just click, we just decide and click and extract the applications. Normally we do the 15 applications per day, more or less. It's the average what the examiners pull, and normally fast tracks have priority over regular track. But as said, our policy, which we established and is working very well for more than 1 year already, is that we always look at the fast tracks from the day before. So these are have priority, and then also we try to clean all the regular tracks older than 4 days. I hope I replied to the question.
Thank you. Yeah, I think it's a very good dashboard now. So we don't have that yet. Okay.
Yeah, it was one of the internal changes we've implemented, and we really enjoy working with that because the examiners are like, let's say, empowered. They have an overview of everything which is unallocated. And then, Kate, as said, normally on average we examine 15 designs. But if out of sudden there are more, especially after the weekend, even though it's not, these are not working days, but people still can file, we have a overview and we know where to concentrate. So if it's the first examination like this dashboard, or maybe to draft objection, which is the second examination, how we call it.
Thank you. Another question. This is really basic, but it's often the case here in IPO field. For many applications with a request for deferment of deferment of the publication, uh, is the 30-month deferment automatic?
No, it's not automatic. The applicants have to indicate it. So sometimes we did have, sometimes we do have such issues that the applicant forgot to mark it in the form. So then they have to call directly the office as soon as possible and as they spot the error, because as we are quite quick, especially with fast track with examination, they have to ask us to stop as soon as possible the examination and not to avoid the publication. So then they have to inform the office, then in writing indicate that they wanted a deferment. So then we will remove the application and then they will have to apply again with the check of the deferment. So it's not automatic. They have to clearly state in the application form, I want deferment or not.
Yes.
If nothing is stated, it will be published.
Okay. So if they you have a payment for the
Yes,
deferment, right?
yes,
So even if they pay the deferment and if it's not indicated, you will also publish the
it
application with
has
that
to be
deferment.
clear. Well, then probably the examiner who's in file will call the applicant. They say, it's a discrepancy, but it has to be very clear that they really want a deferment. If there is any discrepancy, we have to clarify that issue.
Okay, thank you, Monica.
Thank you. I think that was it. Okay. What time we have? So, if we can have the second presentation. In any case, we have time, and I think it'll be quite a quick presentation. Yes, thank you so much to the technicians. Thank you in general for your help. Okay, new types of designs, virtual designs, designs in the metaverse, and issues in the protection. So, I will start my presentation in saying very sad reality, we have no new types of designs because what we had so far was already possible to um, somehow state it in the register. The only thing what happens is that with the changes with the regulation, it's now clearer and it's easier to actually file for a design. So, as Christina was saying, we have the addition of animation, transition, and movement. So, in any case, the indication of product is not legally binding, but the regulation has inserted some clarifications, and it will be definitely easier for the applicants to file certain certain designs. So, like in the case of this one, we have here the animation. This is not a design which was registered yet by us. Hopefully, one day this designer would decide. But what happens is, and I can advance it already, then after lunch I will not have to again repeat it. What happens with the new regulation is that it's easier now to file this kind of design. Uh, we are in the transitional period. We are in the first phase of the regulation. So the applicants can file already something like this, a video, but we still extract 7 views. So, so far until July 2026, the applicants can file the video, but we still work with still images. After the entry into force of the second phase, this will change, and we are already working on adjusting our systems. The executive director will issue a decision on technical things, and also we will see what's in the implementing and delegated regulations, what requirements are set. So also in this case, it will be easier for sure to register something like that. This is water installation from an airport. So far it was a little bit difficult to show it in seven, and it's still probably difficult a little bit to show it in seven views. But as said, as of July 2026, it should be easier. And also what we have are virtual designs, which are already filed for. You can see that virtual spaces we already have in our register. The virtual design, we use it in our official presentations, but it's not a design which we have in our register. What happens here is probably the product indication could be then a little bit changed to make it easier. So now the changes in the definition of a design, as Christina showed in her first slide, actually, they also allow for non-physical design protection. So this definition has been broadened to geographical user interfaces, items intended to form part of an interior-exterior environment, set of articles, etc. So designs can be either physical or virtual, like here, as we say, this is already registered before the reform. But the reform clarified definitely that also the object of protection is becoming defined by the features of appearance which are shown visibly in the application for registration. So, for example, this first one is a little bit dark, the image, but it's something which is visible in the application, but in the real world, what you see here, those white lines, it's the light coming in. So it's an interior, and there are some open spaces which allow light to enter. This light will also move, and obviously at night there will be no light. But as long as this is visible in the application for the design, this could be allowed. And then also displays, projection, virtual interfaces, it will be easier to apply for them. Here, it's also a very interesting example, which we are eager to see if we get such designs, because this is neither physical and nor virtual. What is physical is the apparatus, but the keyboard, it's only there when the apparatus is on. When it's switched off, there is no design, let's say. But these things will be easier than to apply for. So what we have already now is icons. They can be static or dynamic, but still shown within the seven static views, animated characters, holograms, logos. All this we already accept. The only thing that now the legal reform says that this will be possible. So even in the EUIPO guidelines, they say already that designs of screen displays and icons, graphic user interfaces, and other kinds of visible elements of a computer program are eligible for registration. It's class 14 and subclass 4 of the Locarno classification. So what we have also, as I was saying, displays, projections, video games, all this can be already applied for, but we can see that this is a little bit something different from the physical designs that we have, but such designs we are already encounter. For example, we have many interfaces of applications for applications for mobile phones, for example. Uh, but then we will see how things evolve in relation to the product. If the design is generated by a product, if it's shown on a product, or it's only a virtual product. So we will have to see how things are evolving. Well, also in virtual interfaces, virtual spaces, as I was saying, are there. And what we have is the metaverse. We are finding some issues. I see that the video is not, maybe if I now you can see. So we will see then This is like a challenge for us. So, how the protected designs will be used in the metaverse. So, if they will be still the exclusive rights, or how the making, offering, putting on the market, importing, exporting, using of a product will be actually applied in the metaverse. Can we also, the questions which we will have to reply in the future, not yet, is that is if something is available in the metaverse, shall we consider that it's available to the public? It's a disclosure. Will it work as disclosure or not? The jurisdiction, which will be the availability of unregistered designs in the metaverse and the disclosure, etc., etc. So actually, I'm here posing more questions than answers because it's a big unknown for us. And also, yes, who will be then in the future the informed user, the disclosure, the legal framework. So I don't know if you already have any insights on these matters. I see the faces like, hmm, not really convinced. I think I have the impression you actually have the same questions as we have. So maybe in some years we can meet again and then maybe we can have some further insight. So just to finalize my presentation, I can only tell you that so far, with the changes that we are facing of the regulation, some years ago the office did some recommendations for the applicants for the product indication. So, for example, the idea which we conveyed to our applicants was that provide both a physical and virtual product indications for designs who are only intended to be used in virtual environments. Provide both a physical and virtual product indications for designs intended to be used both in real and virtual. And finally, when the 3D design is incorporated in a physical product, then the indications should only be limited to physical product. And basically, that's it. That's the end of my presentation. I'm quite ahead of schedule, but I don't know if you have any thoughts, any concerns about these new realities.